think we should go ahead and get started. So just to introduce ourselves, my name is Natalie Smith. I'm a staff attorney with Legal Services for Prisoners with Children. I'm joined by our senior staff attorney, Eric Sapp, and he will also be presenting with me today. So this presentation is called Disparate Impact on the Future of Disparities in Anti-Discrimination Law. It's the first part in a three-part series on disparate impact, and we'll discuss how this legal theory can be used by advocates to protect the rights of people with criminal records in employment and housing contexts. This first training focuses on the history, development, and current status of federal law on the topic. The upcoming trainings will focus on criminal record-based discrimination in the housing space in a presentation that will be co-led by the National Housing Law Project in March, and in employment, which will be co-led by the National Employment Law Project in April. So to provide a bit of a roadmap for today's presentation, I'll first start off by giving a broad overview of disparate impact in the federal anti-discrimination law and how it's developed over the past 60 years. Eric will then discuss Trump administration's 2025 executive order, which states an intent to remove disparate impact from federal law. He'll then turn to a more in-depth discussion of disparate impact in the employment context. We'll then return to me for a similar discussion in the housing context and end with a discussion of the Department of Housing and Urban Development, or HUD's, new proposed rule on disparate impact and action you can take to oppose it. So what is disparate impact in federal anti-discrimination law? More in general, in this context, the term disparate impact refers to a legal theory that developed out of laws that were passed during the civil rights era that are meant to protect people from discrimination based on membership in a particular group or a protected class that's been historically discriminated against. Protected classes are designated by the legislature through laws, the Fair Housing Act, or FHA, in the housing context, and Title VII of the Civil Rights Act, or CRA, in the employment context. Additional protected classes were added in later legislation. So this slide is listing the protected classes as they currently exist in the US Code. So in the housing context, they're race, color, religion, sex, national origin, disability, and familial status. And in the employment context, they're race, color, religion, sex, national origin, disability, and age. Disparate impact is often used, or is often described in contrast to facial discrimination, which is often also referred to as discriminatory treatment or discriminatory intent. So the definition of discriminatory intent is an action taken with intent to discriminate against a protected class. An example of this would be a landlord that has a policy excluding Black applicants from renting an apartment, or no Black applicants. This disparate impact or discriminatory effect, on the other hand, is the definition of that is a facially neutral action that has a disproportionate negative burden on a protected class. So an example of this would be a landlord has a policy excluding people with felony convictions from renting an apartment. No felons allowed. So while having a criminal record is not specifically designated as a protected class under federal anti-discrimination laws, adverse action taken against someone on the basis of their criminal record may have a discriminatory effect or disparate impact on a protected class due to the concentration of carceral enforcement on Black, Indigenous, and other people of color communities. All right, so this slide is providing a quick overview of the development of disparate impact in federal law and is noting some of the key laws, court decisions, and agency regulations. In this timeline, the origins of the disparate impact theory are clustered in the 1960s during the Civil Rights era, particularly Title VII of the Civil Rights Act and the Fair Housing Act of 1968. You can see then throughout the next about 60 years, lower courts are recognizing disparate impact as a cognizable claim under Title VII and the Fair Housing Act. And then during the Obama era, so about 2012 to 2016, we get a lot of agency guidance and regulations on how disparate impact standards should be applied, both in the employment and housing context. And so me and Eric will go into these in a little bit more depth. So then you see, really in this timeline, this area of law had been fairly stable for about 60 years until we reach Trump to presidency. And last year, Trump issued this executive order 14281, which expresses an intent of eliminating disparate impact from federal law. I'll hand this over to Eric now to talk a little bit more about that.
Thank you very much. Hopefully you can see my slides. If you can't, for some reason, just let me know, or if there's any problems with audio. Thank you very much, Natalie. So I'm going to talk about, first I'm going to talk about Executive Order 14281, and then I'll go into more about employment discrimination. So this executive order came out in April of 2025 and had the title Restoring Equality of Opportunity and Meritocracy. Now, a bit of context for the history of executive orders. So you see Santa Barbara has an interesting database on the history of executive orders, including from 1907 onward, when they were like closely tracked, and then the ones going back into the 19th century that were recompiled. And you'll notice from this chart or this table that in Trump's first term, there was a total of 220 executive orders, averaging 55 a year. Biden was a little bit less than that, averaging 41. And then Donald Trump, in the first year of the second term, issued more executive orders than the entire 4 years combined, for an average of 230 over the years. And to see how this compares historically, we're just going to go backwards in time. You have to read this from bottom to top to go chronologically. Obama had a relatively low rate of executive orders, about 35 per year. George Bush II had about 36 a year, Clinton 46, Bush Sr. 42. And it was slightly higher in the 60s, 70s, and 80s. And to get to a rate comparable and exceeding that of Trump, you have to go back to Franklin Roosevelt, who averaged 307 per year, and the most were in the early years of the New Deal, where he was issuing about 440 a year. And so Trump's first year of his second term was sort of comparable to the Hoover administration prior to FDR in terms of the number of executive orders. So it's definitely a different trend than we've been used to in recent decades. Now, the substance, if you want to call it that, of this executive order emphasizes what it calls meritocracy and a colorblind society as part of the quote-unquote American dream, and argues that a key tool, that the tool of disparate impact liability creates what it calls a near insurmountable presumption of unlawful discrimination, where there are any differences in outcome in certain certain circumstances among different races, sexes, and similar groups. Now, that is like completely a false statement of the law, because first, a plaintiff has to give a prima facie showing of a disproportionate impact, and then there's ways that an employer can argue business necessity and job relatedness in order to justify a facially neutral hiring practice. And at that point, a plaintiff under the Civil Rights Act, Title VII, is able to try to rebut that as merely a pretext. So the executive order completely falsifies the law and then makes a rather bold, the statutory law, and then makes a bold leap to a constitutional argument that suggests that the disparate impact is contrary to equal protection under the 14th Amendment of the Constitution. And in the words of the order, it, quote, imperils the effectiveness of civil rights laws. Accordingly, the president ordered a deprioritization of enforcement of laws such as Title VII of the Civil Rights Act, and a review by all agencies as to how to amend or repeal regulations, guidelines, rules, and orders, including that of the EEOC, which I'll talk about later in the presentation, and which we'll return to in April's presentation. So I end this concluding section with a quote from Camus' play Caligula: "Security and logic don't go together, but there's nothing like insecurity for stimulating the brain." So, disparate impact in employment. And here I'll be focusing specifically on federal law and specifically the Civil Rights Act, Title VII, originating in 1964 and then as revised in 1991. And before I get to the modern world, I want to take a quick step back into the ancient world, as far back as Aesop's fables, but more, which we'll return to in relation to Griggs. But before that, talking about classical Greek philosophy. Now, in Plato's Laws, which was the last dialogue that Plato wrote in the 4th century BCE, there's a passage in which the character, the Athenian, describes a difference between ways in which equality can be conceptualized. One being treating everyone alike, and the second treating differences differently and similarities similarly. It's not particularly, well, it's more explored in relation to voting requirements and wealth rules in Plato's Laws, which is a dialogue basically advocating for a kind of colonization. Plato's Laws is a description of an ideal colony that is imagined to be being created by Cretians with the advice of Athenians. It's an interesting dialogue because Socrates does not appear in it by name, although some people think that the Athenian is supposed to be modeled after Socrates, but really there's key differences between that dialogue and earlier dialogues. Now, Aristotle, Plato's pupil, takes up this differentiation between forms of equality in the Nicomachean Ethics and in the Politics a few decades later. And there's a distinction drawn between arithmetical or numerical equality and geometric or proportional equality. And the difference between what we call numerical equality is that in a given process, an identical treatment is done, versus in proportional, it's rather a ratio proportionate to either the nature or the conditions or status of the actors involved. And Aristotle applies this in the ethics to questions about the nature of personal relationships or friendship, and the politics in relation to questions of political and economic justice. Of course, Aristotle did not have a particularly progressive view of the application of these principles, but nevertheless, the idea that there is a distinction in the way that equality is conceptualized is, I would say, still a formal feature of modern conceptions of equality, including that related to the distinction between disparate treatment and disparate impact. Griggs versus Duke Power Company, coming back toward our era, Griggs versus Duke Power Company was decided by the Supreme Court in 1971, interpreting the Civil Rights Act. This was essentially it's rightly described as a landmark decision, and in terms of interpreting the Civil Rights Act in a manner that enabled disparate impact liability to have a legal foundation. That case, which arose out of North Carolina, had to do with the Duke Power Company's policies of promoting applicants to and assigning to divisions of the company based on eligibility of premised on either a high school diploma or passing one of two tests. Now, it was presumed that, and was not disputed at the appellate level, as to the fact that the the test was facially neutral. It didn't specifically mention race, for example, but that also neither the test nor the diploma could be shown by the company to be related to job performance or necessary to the business. And Justice Berger, not a particularly left-wing judge, wrote for the court in a, again, like I say, a landmark decision that established disparate impact liability. And they pointed out that the company made no showing of a business need and did not have an intention to discriminate. But, and here I quote, "But good intent or absence of discriminatory intent does not redeem employment procedures or testing mechanisms that operate as built-in headwinds for minority groups or are unrelated to measuring job capability." Continuing, quoting from Berger's opinion, "What is required by Congress is the removal of artificial, arbitrary, and unnecessary barriers to employment when the barriers operate invidiously to discriminate on the basis of racial or other impermissible classification. Congress has now provided the tests and criteria for employment or promotion. That test or criteria for employment or promotion may not provide equality of opportunity merely in the sense of the fabled offer of milk to the stork and the fox. On the contrary, Congress has now required that the posture and condition of the job seeker be taken into account. It has, to resort again to the fable, provided that the vessel in which the milk is proffered be one all seekers can use. The Act proscribes not only overt discrimination, but also practices that are fair in form, but discriminatory in operation." Now, what is Justice Berger talking about with this fable? So there's an ancient fable attributed to Aesop around the early 6th century BCE. Also has various modern variants like Fontaine in France in the 17th century, which basically describes a interaction between two animals, one a fox and the other a stork, and it begins with a fox offering a meal to the bird, but in a form that the bird couldn't consume because it was on it was on a platter, and the bird's beak didn't allow it to consume the food in that manner. In which case, then the bird retaliates in a subsequent meal by putting the soup, let's say, in a tall vessel, like a flask, in which only the bird's beak could access the liquid. Now, in Fontaine's version, the moral is basically one of vengeance, to beware of how one treats others, and sort of advocates a kind of poetic justice in revenge, although that's not, I think, Berger's meaning here. The image that I've shown is actually a detail from an early painting by Gustav Klimt in the 1880s, which is uncharacteristic of his style when he was training. Okay, so subsequent to Griggs, I mean, it was, again, a watershed moment, and a number of decisions followed it. Probably the most famous is an Eighth Circuit case, which is nevertheless regarded as, a authoritative statement even by other circuits. Green versus Missouri Pacific Railroad, and that cited an earlier other case, not to be confused, McDonnell Douglas Corp versus Green, which established that the sort of burden shifting, once a prima facie case is shown, burden shifting comes to the employer. But what the Green versus Missouri case did was establish a set of considerations or factors to take into account, and that included the nature of the offense, and job relatedness and time. So one of the statements from the Green panel was, quote, we cannot conceive of any business necessity that would automatically place every individual convicted of any offense except a minor traffic offense in the permanent ranks of the unemployed. This is particularly true for Blacks who have suffered or still suffer from the burdens of discrimination in our society. To deny job opportunities to these individuals because of some conduct which may be remote in time or does not significantly bear upon the particular job requirements is an unnecessarily harsh and unjust burden. Green, found a disparate impact liability, and as I say, became a pretty important basis for subsequent development of the law. Now, as mentioned, in 1991, and so this would be sort of in the very middle of that timeline, which Natalie shared earlier, sort of put right in the middle, there's a revision to the Civil Rights Act in which Congress codified the disparate impact standard and clarified or tried to clarify, but actually, I think a somewhat confusing way, the standards of construction for that. But of course, as with most issues relating to discrimination law, there has been since, increasingly in the past, half century, there has been a pushback, and the conservative movement or right-wing judicial interpretations have tried to constrain disparate impact and potentially even argue that it's inconsistent with equal protection law. Now, the idea of equal protection as specifically about the animus or motivation or intent is a very problematic and dubious interpretation of the law, but it's one that comes up again and again, and as we saw earlier, is mentioned also in the executive order when it signals an interest in the equal protection angle. One of the cases in just about a decade and a half ago, which dealt with this issue, was Ricci versus DeStefano, which reached the Supreme Court in 2009. It arose in the city of New Haven in relation to the firefighting exam for hiring firefighters. There, test was promulgated and administered and was pending the certification of the results. And ultimately, the Civil Service Board of the city declined to certify the results. And some of the test takers, mostly white test takers, sued, arguing that it was racially motivated, the non-certification, and that it violated both the Constitution and the Civil Rights Act. The constitutional question was never reached by the court. It only decided on in relation to the statutes. Now, the city's response was that it did not certify the results because that the test had a disparate impact, and it feared being liable under the Civil Rights Act for violating that act. Kennedy wrote for the majority, a somewhat, let's say, well, let's put it this way. Ginsburg in her dissent says she didn't believe that the majority's opinion has any staying power, which is, I suppose, a more dignified way of saying it's poorly written and incoherent in its reasoning. Nevertheless, Kennedy posited that there was essentially like a catch-22 that the city faced, that either it would be violating disparate impact or it would be violating disparate treatment. Again, just sticking to the statutory concerns, and that nevertheless, it did not have sufficient evidence for its concern that it would be violating disparate impact, and so that did not justify its deployment of what the court assumed was a racially discriminatory treatment with respect to the test results. So not exactly out of whole cloth, but sort of imported from a different context, the court held that the city would have to have a quote unquote a strong basis in evidence that would support the disparate impact liability. And if it didn't have that, it had no basis for using racial criteria or race conscious criteria for decertifying or not certifying the test results. Again, this was a divided court. Ginsburg wrote a lengthy dissent, which was joined by Souter, Breyer, and one other justice, and argued that the conflict between disparate treatment and disparate impact that was not real, and that the court had sort of invented it and instead offered what she called an enigmatic standard. Employers may attempt to comply with disparate impact provision only where there's a strong basis in evidence. This is describing the court's position, documenting the necessity of their action. The court's standard, drawn from inapposite equal protection precedents, is not elaborated. One is left to wonder what cases would meet the standard and why the court is so sure this case does not. Now, I think Ginsburg's critique of the court's invention of this evidentiary standard is a valid one. On the other hand, the denial that there's a tension, at the very least, a tension between disparate treatment and disparate impact, is somewhat disingenuous or naive, and doesn't sort of help a realistic assessment of the crux of the problem. Alito wrote a concurrence joined by Scalia and Thomas, which was basically completely fact specific and was going into the nitty gritty of New Haven political wrangling between politicians and organizers, and is an interesting perspective, but has almost no juridical value. What does have juridical importance, although one can debate its soundness, is Scalia's solo concurrence. And I want to focus on that because it relates back to the equal protection element in Trump's executive order. Scalia wrote, as he put it, quote, to observe that the court's resolution of the dispute in Ricci merely postpones the evil day on which the court will have to confront the question whether and to what extent are the disparate impact provisions of Title VII of the Civil Rights Act consistent with the Constitution's guarantee of equal protection. Scalia considered that it may be possible to defend the law by framing it as simply an evidentiary tool to identify what he calls genuine intentional discrimination to smoke out disparate treatment, and that disparate impact is sometimes a signal of something illicit. So a regulator might allow statistical disparities to play some role in the evidentiary process. And then he strangely spins the McDonnell-Douglas Court case mentioned earlier to support that view. Now, you can see from the language that he's using that Scalia thinks only intentional discrimination is a legitimate legal basis for finding discrimination or disparate treatment, and that disparate impact is only valid as a sort of means for finding disparate treatment. This flies in the face of a whole half century of judicial precedent, and congressionally clearly articulated congressional intent and statutes that make disparate impact a independent basis beyond disparate treatment. But nevertheless, Scalia continues. Quote, this is a question the court will have to consider in due course. It is one thing to free plaintiffs from proving an employer's illicit intent, but quite another to preclude the employer from proving that its motives were pure and its actions reasonable, end quote. Again, this sort of strangely moralistic language of illicit intent and purity of motives turns the question of discrimination into a sort of moral drama of the subjective motivations, thoughts, feelings of the employer or other discriminators, rather than a strictly legal and social question of the distribution of opportunities and power. Scalia concludes that dissent in a even more inflammatory way. Quote, after noting that his whole opinion was totally unnecessary to resolve the matter, so even if he had prevailed, it would have all been, I suppose, dicta. He says, quote, the war between disparate impact and equal protection will be waged sooner or later. It behooves us to begin thinking about how and in what terms to make peace between them. On that, I think he's absolutely right. It behooves us who sort of disagree, if I may be permitted to express my own opinions, it behooves those of us who disagree with the ultimate resolution that Scalia is advocating. It behooves us to take seriously this war that he describes, so that we are prepared to fight it in a more strategic and clear-sighted manner. So I'm going to say, just so I don't go too far over time, a few words about the 2012 EEOC guidance, and we will return to this in session 3 of the series in April. So during the Obama administration, there was a guidance on the consideration of arrest and conviction records in employment decisions under Title VII. Interestingly, it essentially, and again, these are guidelines, these are not hard law, but it said that arrest does not establish criminal conduct occurred, and exclusion based on arrest in itself is not job related and consistent with business necessity. That's pretty strong statement, although it does allow for the employer to look at the underlying conduct. On the other hand, its protection with respect to convictions, I think, is considerably weaker, and especially the way it looks at the green factors leaves a lot of room for employers to justify the business necessity of an exclusionary practice. The EOC said that they predict, or they put forth the position that employers will normally meet job-related business necessity if they either fulfill the guidelines for selection procedures that are outlined at Title 29 of the Federal Registry, Section 1607, or if they do targeted screening that satisfies green factors of nature of the crime, elapsing of time, and nature of the job, and then provides an opportunity for an individualized assessment where the applicant can rebut an unfavorable ruling under those factors. And last but not least, if the plaintiff can find less discriminatory alternatives, they can still defeat the employer's justification. As I said, the characterization by the EOC in 2012 of the nature and gravity of the offense factor is pretty weak. It includes such a banality as theft causes property loss as an example of the sort of rubric under which an assessment could take place. But I think one should regard that as simply an inadequate analysis and not indicative of the actual law. So I will turn it over to Natalie to talk about housing and look forward to the questions.
Okay, thanks, Eric. Let me get my slideshow back up. Okay, is everyone seeing the slides? Eric, can you just confirm they look okay? All right.
No, they're currently in presenter mode. So I think you need to minimize the presenter view.
This? Okay, let me try again. Sorry. Is that better, Nanaya?
Yes.
Okay. And also, sorry for not introducing Nanaya in the beginning. Nanaya is our supervising attorney and is helping moderate this training, and will also be helping run the Q&A at the end. Okay, great. So to turn back to the housing context, I really want to start by highlighting the origins of disparate impact in the Fair Housing Act, or the FHA, to really underscore the purpose of the legal theory. So after years of fighting against racial segregation, organizers in the civil rights movement catalyzed the passage of the Civil Rights Act of 1964. In addition to establishing protections against employment or discrimination in employment and education, Title VII of the Act ended de jure or legal segregation in public accommodation. However, the Act did not address segregation in housing, which allowed discriminatory practices such as redlining to continue unchecked. Organizers continued to push for equal rights in the housing market, and in 1966, a series of open housing marches led by Dr. Martin Luther King Jr. put the issue of fair housing on the national stage. 2 years later, Congress enacted the Fair Housing Act, or FHA, in Title VIII of the Civil Rights Act of 1986 to prohibit discrimination in the sale, rental, or financing of dwellings and in other housing-related activities on the basis of race, color, religion, sex, or national origin. Familial status and disability were subsequently added to the list of protected classes. So this slide has the definition of discriminatory housing practice as it's defined in the Act and codified in the U.S. Code. So the FHA doesn't use the term disparate impact or discriminatory in effect explicitly when defining unlawful discrimination against a protected class, nor does the statute specify a standard for proving discriminatory effects violation. However, in the decades that followed the FHA, 11 federal circuit courts of appeals interpreted the act to prohibit practices with an unjustified discriminatory effect, regardless of whether there was an intent to discriminate. And Eric talked a bit about those in the housing or in the employment context as well. Okay. So similarly, the Department of Housing and Urban Development, or HUD, which is the agency that's statutorily charged with interpreting and enforcing the FHA, agreed with the court's interpretation that practices with discriminatory effects might violate the Fair Housing Act. So they have been issuing guidance recognizing disparate impact liability as early as 1993, but in 2013, HUD issued formal rules on the implementation of the Fair Housing Act's discriminatory effects standard with an intent to formalize the longstanding view that discriminatory effects is cognizable under the act, and they were trying to really establish a uniform standard for determining when a practice with a discriminatory effect would violate the Fair Housing Act. Okay, so in addition to defining what disparate impact meant, the 2013 regulations also created, or I guess sought to find uniformity in the burden shifting test. It's pretty similar to the one that Eric described in the employment context. So as step one, the plaintiff must show that a challenge practice caused or predictably will cause a discriminatory effect. If the plaintiff does that, then it shifts over to the defendant to show that the challenge practice is necessary to achieve one or more substantial, legitimate, non-discriminatory interests. If the defendant does that, it shifts back to the plaintiff, and the plaintiff can still prevail if they show that the defendant's non-discriminatory interests could have been served by another practice that has a less discriminatory effect. Okay. So 2 years later, the Supreme Court held 5-4 in Texas Department of Housing and Community Affairs versus Inclusive Communities Project that disparate impact claims are cognizable under the Fair Housing Act, and emphasized that lawsuits must rely more on just a statistical disparity. They have to show a robust causality requirement to show that a specific policy caused the disparity. So these are the test that they're using is pretty similar to the one in the 2013 regulations. They're just adding a robust causality requirement. Okay. A year after that, we get HUD's 2016 guidance on the use of criminal records in real estate related transactions. So they said in this guidance that while having a criminal record is not a protected characteristic under the Fair Housing Act, criminal history-based restrictions on housing opportunities violate the act if, without justification, their burden falls more often on renters or other housing market participants of one race or national origin over another, i.e. discriminatory effects liability. So this guidance is a really helpful piece of legal authority for advocates that are working with clients that have criminal records and are facing barriers to housing. The test that's laid out in this guidance is very similar to the 3-part burden shifting test that's used in the 2013 rule. The guidance also calls out specific practices that are unlikely to satisfy the defendant's burden in part 2. So a practice that's unnecessary to achieve substantial, legitimate, and non-discriminatory interests, such as exclusions based on arrest records and blanket bans, as well as practices are likely to be found a less discriminatory alternative under Part 3, such as individualized assessments of an applicant with a criminal record. So unfortunately, in 2025, in the end of last year, HUD issued a memorandum that was rescinding guidance related to disparate impact liability under the FHA, including this 2016 guidance. And in November, they similarly rescinded some 2015 guidance that was specifically for federally assisted housing on excluding the use of arrest records in housing decisions. So just as a side note here, like, this is obviously bad. California has its own laws that are protecting residents from discrimination in intent or effect, and some cities even have more protective ordinances. But this was really a key piece of federal guidance on this that has now been rescinded. So in the later training in March, we'll talk a little bit more about what remains in California as well. Okay, also in bad news, HUD is proposing, they recently released like 2 weeks ago, some proposed regulations on disparate impacts. And the effect of this will be to repeal their 2013 regulations, essentially. So their rationale for doing this, they're citing the executive order that Eric had mentioned, and they're also citing the Supreme Court decision from 2024, Loper-Bright, which held that agency rules carry no deferential weight in court. A quote from the notice of proposed rulemaking was that they're saying it's appropriate for the courts, not a federal agency, to make determinations related to the interpretation of disparate impact liability under the Fair Housing Act. They also have a shortened comment period, typically at 60 days. Now we're only getting 30 days to submit comments. Comments are due on February 13. And I have a little bit more information on that at the end of this presentation. But I really encourage folks to submit comments if they're able to. Okay, so if this new HUD regulation goes through, we're left with a question of what law governs. So here we have the hierarchy of statutory and regulatory authority. We have on the bottom guidance, then you have regulations, then you have statutes. So we lost that good 2016 guidance, and we might lose some of the good regulations, but we'll still have the statutes. Okay, but what about the court versus the agency kind of interpretations of the statute? Okay, well, we used to have Chevron, where Chevron's saying that the court is going to not overrule an agency's interpretation in appropriate circumstances. So under Chevron, judicial interpretations were kind of going under the regulations. However, that's been overruled by Loper-Bright. So now we're getting judicial interpretations maybe somewhere like this, above the regulations. Eric, you can chime in if you disagree, but the executive order, I think, is just kind of floating somewhere out here and really only governing in the effect that it affects what the agencies are doing. Okay, so I just want to kind of summarize what might happen if the 2016 regulation passes. Basically, we would expect to see a shift towards more reliance on judicial interpretations of disparate impact liability under the FHA and some variance between circuits and jurisdictions, as well as more reliance on state laws rather than federal. It's also important to note that HUD could change the rule back again in the future. And we saw this a little bit before. They had been trying to, change the 2013 rule and ended up changing it back, and now they're trying to get rid of it entirely. So it's just important to remember that's kind of a politically contingent. And we still have a lot of court precedent as well. So as I mentioned, HUD is seeking public comment. You can submit a public comment here. Just comments are due pretty soon. So we also attach like a little explainer from the Immigrant Law Resource Center on how to submit a public comment. And I think that LAAC is sending those all out after this training. And LSPC is also working on a comment. You're welcome to reach out directly to me if you're interested in collaborating or joining in on ours. Okay, and with that, let's open it up to questions.
Thank you. So the first question that someone has is, can you share a template for the HUD public comments or public comment we can sign on to?
Yeah, let me look. I saw that the National Low Income Housing Center had one. I can find that and drop it in the chat.
Yeah, and there may be an opportunity this time around or in the future for us to do public comments that folks can sign on to. And then someone asks, will a recording be sent out? And LAAC trainings responded, yes, we'll send out a recording within 1 week of the event to everyone who registered, and it will be accessible at blackonline.org.
Just to jump in and answer the, I suppose, maybe rhetorical question that Natalie posed to me about the pyramid of authorities. I guess I would put the executive order underground, underneath the pyramid. If I could use a analogy to California administrative law, and underground regulation is a kind of written policy that hasn't gone through a regulatory process, and so is not a legally valid administrative law. Ordinarily, you don't need such a thing. Certainly, you don't need such a thing in the federal context with an executive order. But because the content of the executive order is so blatantly contradictory to federal law, it sort of has the character of an underground policy, even though it's promulgated publicly. Interestingly, and I encourage folks to ask questions so I don't fill time with my blather. But I want to point out that when you go to the White House's websites to access the executive orders on the White House website, as opposed to the preferred way of getting it through the Federal Registry, you'll get an annoying pop-up every time you revisit the site that wants you to join the mailing list, and you can't access the material unless you figure out a way to get rid of that pop-up, which is sort of good emblem for the right-wing populism that this executive order embodies.
Okay, another question. Do you recommend that California still write letters to landlords or housing authorities on behalf of tenants whose housing applications were denied based on blanket bans on past arrests?
So I would say yes, because the California laws are a lot more protective than the federal ones. And as of right now, the 2013 regulations are still in effect, as well as the 2015 case from the Supreme Court finding disparate impact to be cognizable. So this is still a basis for advocacy with landlords.
And you can also file a formal complaint with the California Civil Rights Department, and if the Civil Rights Department will look at the basis of the claim and possibly investigate. And if you're very lucky, maybe take the case.
Yeah. I think this next presentation in March is going to focus more on housing, and we'll have some more kind of like practice focused tips for people in California that will draw more on state law.
And as a reminder, so yeah, the second session is in March, and then on housing, and then in April there'll be another session on employment. I'll continue with the 2012 EEOC guidance, and in the not terribly unlikely event that it gets amended or repealed, we'll also look at whatever new guidance the feds issue, if they do, and if not, we'll look at we'll go into detail in California law. So either way, there should be plenty to talk about in these future sessions, and we'll be joined by other partners in both of those sessions. So please join those sessions.
Okay, there's another question. Are there still practitioners actively filing claims with EEOC based on disparate impact theory in criminal records cases, or has there been a chilling effect given the current administration's policies?
Well, there probably has been, but you know, the law still is the law still is the law. So people still should file complaints with EEOC, and then either get or encourage them to give you a right to sue letter in the event that they don't agree with your case, and then you can pursue civil action privately in the event that you have a meritorious claim that doesn't get picked up by their enforcement authorities.
Okay, I think that's about all we have time for. I'll turn back over to LAAC in case you have anything you want to say to wrap up.
Thank you so much for your time today. It's always a pleasure to work with you all on your presentations. Really appreciate it. And I hope to see all of our attendees at future training sessions in this series. This webinar was recorded, as we said, and it'll be uploaded to the LAAC website within 1 week of the event. You'll also receive your MCLE certificates within 1 week to the email address used to register for this event, and it's eligible for 1 hour of general MCLE credit. And I'm popping some links in the chat. Please fill out the link that Natalie sent to complete an evaluation of this training as well. And thank you all so much.